good afternoon, as the case may be, or good morning if you're further west than the East Coast in the Eastern time zone. Now, my name is Barry Penner. I'm the Managing Director of the Canadian International Internet Dispute Resolution Centre, and I'm here to introduce our program, a great debate over domain name disputes. We will be having a conversation amongst internet law experts debating controversial domain name arbitration topics for both your information and, we hope, your entertainment. First, just a little bit about us. The CII-DRC, or Canadian International Internet Dispute Resolution Centre, was established now 3 or 4 years ago, but it's a subsidiary of the Vancouver International Arbitration Centre. And we have been in existence since 1986 and have been handling internet domain name disputes on behalf of the Canadian Internet Registration Authority, CIRA, since about 2002. So we have a long history there, but then branched into doing uniform domain name disputes as well back in 2019 with the establishment of our wholly owned subsidiary, CII-DRC. I joined the Vancouver International Arbitration Centre, and CII-DRC was established a couple of years after I joined in 2017. And a bittersweet moment for me today. Very pleased to have this discussion today, but this is my last day with the Vancouver International Arbitration Centre and CII-DRC. And so looking forward to this presentation, and very pleased at all the work that we've been able to accomplish over the last number of years. Without further ado, I'd like to introduce our moderator for today's webinar. His name is Doug Eisenberg. Many of you will know him as the founder of the GigaLaw law firm in Atlanta. He has been practicing law and focusing on domain name disputes for more than a quarter of a century. Doug serves as a domain name panelist for CII-DRC, as well as for most of the other providers for the Uniform Domain Name Dispute Resolution Policy, UDRP. He frequently represents clients in domain name dispute proceedings, including the largest UDRP complaint that has ever been filed. Doug regularly publishes case study videos about domain name disputes, which you can find on YouTube, and also publishes a quarterly digest that tracks and analyzes domain name dispute decisions. Another one of our panelists today is Michelle Easton. We're very pleased to have her. She's a partner at Gowling WLG, practicing in the trademark area of law since joining that firm in 2006. Michelle provides full trademark services to domestic and international clients, including prosecution, transaction advice, trademark cancellations, oppositions, and litigation. She also specializes in global trademark portfolio management, strategy for enforcement, and internet-related intellectual property issues, including filing domain name complaints on behalf of brand owners. Daniel Anthony will be joining us as well. He is a trademark, copyright, and internet law specialist with Smart & Bigger in Ottawa, Canada. Daniel assists clients in all aspects of securing and enforcing their intellectual property rights, with a particular emphasis in online enforcement. Daniel has recovered hundreds of domain names, is a panelist for .ca disputes, and is the past president of IPIC's Canadian Internet Law Committee. And finally, we have Zach Moskovich. Zach is a Canadian intellectual property lawyer based in Toronto. Zach has practiced domain name and trademark law since 1999. And since then, he has acted as counsel for complainants and respondents in over 100 contested UDRP and CDRP cases. Zach has appeared as counsel in domain name disputes in the Ontario Superior Court, the Federal Court of Canada, the Federal Court of Appeal, and Zach is an accredited CII-DRC panelist for both UDRP and CDRP disputes. He is general counsel to the Internet Commerce Association. So enough about that and enough about me. I'd like to turn it over to Doug Eisenberg now to moderate the session.
Great, thanks, Barry. I appreciate the introduction, and I'm sure, like all of our panelists, I'm honored to be here today to moderate what I hope, as you said, will be a lively and informative debate about just a few of the most important issues that are facing trademark owners and domain name registrants in domain name disputes today. So my role is simply to introduce the topics that we're going to be talking about and to facilitate the conversation. I don't plan to speak a whole lot, which I'm sure will disappoint nobody who is listening today. But I just want to say a few words at the outset. First of all, as Barry said, We have a great group of debaters today, and they have volunteered to argue for positions solely to bring issues to light and to make clear the strengths and weaknesses of specific legal positions. But it's important to note that the arguments you'll be hearing do not necessarily reflect the debaters' personal perspectives or the positions of any of their clients. In other words, this is really just an academic exercise for everyone's education and nothing else. Second of all, while the CII DRC has organized this webinar and all of our wonderful debaters today are Canadian, I am not, I am American. This obviously does not disqualify me from fulfilling the role of moderator, or for that matter, from filing complaints at or drafting decisions for CII DRC as I regularly do. But the real reason I mention that is to note that there's a broader issue here, which is that this program will focus not solely on the Canadian Domain Name Dispute Resolution Policy, or CDRP, but also, and probably even more so, on the UDRP, the Uniform Domain Name Dispute Resolution Policy. And that's simply because the UDRP is a much more popular domain name dispute policy because it applies to .com domain names and more than 1,000 other top-level domain names for that matter, whereas the CDRP, of course, only applies to .ca domain names. Fortunately, though, the UDRP and the CDRP, if you did not know already, are very similar, though not identical. So many of the arguments that you'll hear from our panelists, excuse me, are applicable to both domain name dispute policies. In fact, the CDRP itself in the rules says that parties may cite decisions under other relevant domain name dispute policies. So it's pretty common to see references to the UDRP in actual CDRP filings and decisions. And then finally, one final housekeeping note, we're planning to cover 3 specific substantive topics today, and we will have a short poll before each of the 3 accompanying debates. So I encourage you, please, to participate, to answer the questions that you'll see on your screen based on what you know now, and then maybe after each debate concludes, you can reflect on whether and how maybe the arguments may have changed your mind. Once the debates begin, each debater will have 4 minutes to present his or her position. There will be a chime with 30 seconds left, and then another chime at the end of the 4 minutes, followed by the other debater, and then we'll have a couple of minutes for questions. So I also encourage you, please, there's a Q&A button at the bottom of your Zoom window. So please submit your questions. If you can multitask while you're both listening to the debate, you can submit your questions at the same time. So we'll have those immediately. So with all of that housekeeping out of the way, let me introduce our first topic, and then we'll put up the poll in just a moment. So the first topic up for debate today relates to the issue of what role the content on a website that is associated with a disputed domain name should play in a domain name dispute. As I often say, there are a lot of different types of cyber squatting, some of which, like phishing, don't necessarily involve a website, but usually the content on a website is at the heart of a domain name dispute. On the one hand, it might seem like a domain name registrant is uniquely responsible for the content on a website, but sometimes a registrant might claim to be unaware, for example, that a registrar automatically created a pay-per-click page. So the first poll question for you to answer, let me get it up on the screen here, relates to this topic. Bear with me. Poll question number 1, there we go. Hopefully you're seeing the poll question now. And you can answer, we'll keep it open for 30 seconds or so, answer whether a respondent is responsible for content that appears on a website using a disputed domain name. Give it about 10 more seconds. Okay, as promised, that was 30 seconds. And hopefully you can see the results there, which are pretty interesting. So 80% of those who answered the question said that a respondent is uniquely responsible, or a respondent is responsible rather, for content that appears on a website using a disputed domain name. So first up to argue that a respondent is responsible for the content is Daniel Anthony. So Dan, go right ahead.
Okay, thanks, Doug. Obviously, I say that a respondent is responsible and is always responsible for what appears on the associated website to their domain name. Registering a domain name is a privilege. It is not a right. Every domain name is subject to contractual terms and conditions. It's fundamentally a contract between you and the registrar backed by ICANN. If you were to use a domain name for terrorism, well, you're going to lose it. If you don't pay your renewal, you're going to lose it. If you select a domain name that's also a trademark, and somehow through your proactive steps or by accident allow the website to be used in a way that harms that trademark, it's going to be found to be in bad faith and you're going to lose it. So fundamentally, I would ask you, and I know a lot of you are already leading this way from the poll, if the domain name owner is not responsible for the content, who is? Now, before I get too deep into this, I don't want to go after the unique case where somebody hacks your website and puts something up, that you had no control over. We're really talking about a typical case. And so the first point that I like to keep in mind is that when you're doing a UDRP or a CDRP, the brand owner needs to show they have rights that predate the domain name. That's fine. There's a legitimate interest step where the owner can show that they had some legitimate interest, which would trump bad faith. But the third step of bad faith, which is really where the content is coming in typically, it doesn't actually require intent. You don't have to intentionally want to hurt the brand owner. It's sufficient that you do things that qualify for bad faith. So if I register a bunch of brand names and I have a pattern of conduct and I'm blocking them from using their domains, that could be bad faith, even if I was completely naive as to the law. Maybe I don't know what a trademark is. I think I've had a brilliant idea to register Nike.ca to sell it back. The intention in your heart isn't what matters. It's really the action that matters. The other thing I think we should keep in mind is there is a get out of jail free card available, even if you've got some problematic content, maybe, if you can show proactive, legitimate interest. So that second factor, if I can show that I have a brand called Nike for my toilets, let's say, and I registered Nike, but then the registrar, before I could set up my webpage, he put up some sort of pay-per-click targeting the famous clothing and shoe company, Nike. I could show that I had my trademark in place and I was just getting things set up. So I'm always going to have the chance to prove legitimate interest. But when we look at a website, we have to assume that the content is the responsibility of the owner. And if there's something fishy, it's probably bad faith content. If you look at the WIPO 3.0 overview, section 2.9, it specifically states that the consensus view is that a web host parked page with pay-per-view links, pay-per-click links, is not considered good faith. There's also a statement in WIPO 3.2.2 that says that many panelists will apply the principle of registrants should know or did know if it's a famous name because the internet is so available. And in WIPO 3.2.2, it says that willful blindness is not a defense. And in 3.5, that automatically generated websites are fundamentally the responsibility of the owner. So I say in a world where it's easily verifiable what's on your website, what your registrar is up to, you can deselect the blocks to say, I don't want a parking page. You can control your web developer. The registrant is always responsible whether they meant it or not.
Great. Okay. Hopefully the chimes were not too disturbing, but we're good.
They were totally awesome because I hit the chime on the dot.
Great. Good audio cues just to keep us on track. We've had a couple of questions come in during the Q&A. I'll just reiterate that we as the panelists and moderator are seeing the questions that you're submitting, so we'll get to those in a minute. But that was great, Dan. Next, we're going to hear a counter argument from Zach Muscovich, excuse me. So Zach, I will turn the floor over to you.
Well, thank you, Douglas, and thank you to the CII-DRC for putting this on. And Barry, we're going to miss you. And Ina, thank you for organizing this. As a Canadian, the CII-DRC has made us all proud with a world-leading dispute resolution provider. So thank you for that. So you've heard from my friend Daniel, rather harsh view of the UDRP. He did a great job channeling a kind of Torquemadan view of it. But really, the UDRP at its heart has to do with bad faith, in Latin, mala fides. And with the UDRP, what we're trying to do is discern, figure out what was actually the intention of the registrant at the time they registered the domain name. Cyber squatting is not a strict liability offense. What we are trying to do is discern what their motivations and intentions were in registering the domain name. So there's plenty of examples of when a registrant or a respondent in a UDRP or CDRP is not responsible for the content of the website. We may see that 96, 97% of cases in these two types of procedures involve cyber squatting, but we must always be aware that a general rule has major exceptions to it. We must pay attention to those. The easiest example, which Daniel mentioned, of when a respondent isn't responsible, is if they were hacked. We would all agree that the respondent, generally speaking, would be responsible for that. A less extreme example is if the infringing content on a website associated with a disputed domain name occurred before the registrant even registered the domain name. We would all generally agree that what happened before the registrant doesn't make the registrant responsible. And if you go along that vein a little further, if someone registered a domain name in 1999, for example, and the bad PPC links or infringing content didn't arise until 15 years later, it's probably a less of a good indication of what was in their mind 15 years earlier at the time of registration. Now, expert domain name registrants may be fully apprised of the registration agreement that they're asked to sign with a click when they purchase a domain name for $12, because most of the general public isn't. Most of the general public wouldn't read what documents that are sometimes 10, 20, 30 pages long with all kinds of fine print that says that the registrar may populate an unused domain name with advertisements solely chosen by their registrar. This would come as a complete shock to someone. Picture your mother or grandmother seeing a commercial for a popular registrar, registering the domain name, and then being totally innocent of what appears on that website because it was the registrar that used an algorithm to populate the website. A second example that often arises, well, not often, but sometimes arises in UDRP and CDRP disputes is when a complainant, realizing that the general rule is that a respondent is responsible for what appears on a website, manipulates the content on the website. How do they do that? Well, if you can envision a simple pay-per-click landing page that has a search bar in it, and none of the links infringe the complainant's trademarks, that can be manipulated by entering in the search term, entering as a search term your trademark. Lo and behold, you have infringing links. And so that's another example of when a registrant or respondent is not responsible for the content. A second example is when a complainant pays for the links. Paying for the links will obviously result in ads. The search history of a complainant can also manipulate the outcome of the ads. Taking all these things into account, although it may be a presumption that in most cases a respondent is responsible, in many cases it is not. Thank you.
Okay, great. Thanks. Zach done slightly before the bell. We only have a couple of questions have been submitted, and they're essentially along the lines of course, the real answer here is maybe. We specifically designed these questions to not necessarily have crystal clear answers. That's what makes for fantastic debates. With that said, with no direct questions, but still feel free to enter them as we go. Dan, and any responses that we'll give you then, each of you a minute to respond to the other. Dan, if there's anything that Zach brought up that you might want to add to.
Yeah, I was empathetic to Zach's position about the grandmother who didn't read the 30-page contract and wanted to not be responsible for GoDaddy's, aggressive pay-per-click advertising. But at the end of the day, this is business. And if she loses that domain name, she can just get another one. I mean, they're infinitely available. Just put a couple of hyphens in. And so I say that unless you can proactively show what your plan was and have kind of overwhelming evidence of good faith to contradict that, you're still liable for what your registrant does. And if your registrant is doing that all the time, use a different one that's not so aggressive.
Does it matter, and I'll throw this out to both of you, Dan and Zach, does it matter who the registrant is? If the registrant is somebody who is a so-called professional domainer who may be in the business of monetizing and acquiring and selling domain names, or somebody who does not have that background, is that a relevant factor to consider?
Yeah, yes, Doug. I think many panelists will consider that as an important factor, so that a professional domain name investor will be deemed to be more aware of the implications and the requirements under his or her registration agreement. On the other hand, though, many people don't realize that those automatically populated PPC links on a standard registrar lander, none of the benefit of that goes to the registrant. It all goes to the registrar. And so one must then ask, what really would be the motivation for the registrant to do this? Does it speak to their intention in registering the domain name, or is this collateral damage that, although some people may hold them responsible for, doesn't reflect on their bona fides or malifides?
And I think what's interesting there, if you want to respond to it, or I'll just throw out the thought, that is information that's not necessarily known to a would-be complainant before the complaint is filed. And so is it appropriate perhaps to reconsider a complaint after more information comes to light, or should the trademark owner have done more homework? What more homework could a trademark owner possibly have done before filing the complaint?
It's a good point. And I'll say this, I'm not 100% convinced that sometimes registrants can't get a cut of the parked page. And there's possibility that a registrant could knowingly allow a parked page to trigger a brand owner to want to deal with it and make an offer. So they're not directly profiting, but it is antagonizing the brand owner to try to buy it back in a way that a totally passive page might not.
Yeah, I would say that it's often difficult for professionals in this field to discern the difference between a lander that a registrar is reaping all the profits from versus a registrant.
So just one quick comment in the Q&A, and if you want to respond, and then we'll move on. But the question says, in Ontario, domain names are considered property. Landlords of physical property are not responsible for the behavior of their tenants. For example, commercial property. If a domain name is licensed in good faith, why would the domain name owner be liable rather than the licensee, is the question.
I don't totally agree with the premise. Ontario case law does say it's personal property, but I don't think the registrar is the landlord. I think the owner of the property is the registrant. The registrar is obviously providing a service, but you can go to any registrar. They're really an intermediary. And so I think that at the end of the day, there's only one owner, and they're not a tenant. They're a pure owner and title of a piece of land, digital land, and they're responsible.
Great, thanks. And just to address one other question that came in while I was speaking, then we really will move on. I don't know that this needs a response unless you want one. But the question says, most PPC, that's pay-per-click advertisements, are provided via Google or similar providers. In almost all cases, participation in the program requires the trademark owner to grant a license to use and display the trademark in any advertisement page, including channel advertisements appearing on PPC pages. PPC advertising is channel advertising. Given that license isn't a domain, given that, sorry, I'm trying to read the question here. Given that license isn't a domainer using PPC simply acting as permitted by the licensee or by the license.
I'm going to have to ask ChatGPT the answer to that question. So.
All right, well, let's move on then. That was a great discussion. Keep the Q&A coming as we move along, but we will now move on to our second topic. And this relates to the issue of domain names that consist of or perhaps contain only dictionary terms or geographic names. And these have made for some pretty interesting disputes under both the UDRP and the CDRP. And I think our panelists might be talking about some specific cases today. So the WIPO overview, which was referred to earlier, and by the way, it's a great resource that's often cited by parties and panelists in CII DRC cases. The WIPO overview addresses this issue and uses this example that I'll just quote here. It says, a hypothetical respondent may well have a legitimate interest in the domain name orange.com if it uses the domain name for a website providing information about the fruit or the color orange. The same respondent would not, however, again, reading from the WIPO overview, would not have a legitimate interest in the domain name if the corresponding website is aimed at goods or services that target a third-party trademark, such as Orange, the well-known European company for telecommunications and internet services. You know, what's interesting here is both trademark owners, I think, and domain name registrants can cite or abuse this issue. So what do you think? Let's launch our next poll. Hopefully you can see it there. Go ahead, we'll take about 30 seconds and cast a vote yes or no about whether you think registrants have an inherent right to domain names consisting solely of dictionary terms or geographic names. About 10 more seconds. Okay, we will close the voting. And so this was a fascinating outcome, almost evenly split. 46% say yes, the registrants have an inherent right to domain names that consist solely of dictionary terms or geographic names, and 54% said no. So to address the topic first, to advocate on behalf of the yes answer, we'll hear from Michelle. So Michelle, go ahead.
Thank you. Well, my short answer is no. Registrants do not have an inherent right to domain names consisting solely of dictionary terms or geographical names. And the reasons why are, panels have recognized that merely registering a domain name comprised of a dictionary word or phrase or a geographical name does not by itself automatically confer rights or legitimate interests on the respondent. Rather, in order to find rights or legitimate interests in a domain name based on its dictionary meaning or geographical name significance, the domain name would need to be genuinely used or at least demonstrably intended for such use in connection with the relied upon dictionary meaning or geographical name significance, and not to trade off third-party trademark rights. This inquiry is highly fact-specific, and complainants that have standing to file a UDRP complaint against dictionary or geographical name domain names must really carefully assess the merits of the case before proceeding. In determining rights or legitimate interests or lack thereof, panels will look to a number of factors, including the fame of the relevant mark and the way in which the domain is used, specifically website content. The complainant's case in a nutshell is to demonstrate with evidence that a respondent knew of its trademark rights and has sought to take unfair advantage of, abuse, or otherwise engage in behavior detrimental to the complainant's trademark. In other words, there is targeting of the complainant or its competitor. For example, the domain name is used to host a PPC page with links that compete with or capitalize on the reputation and goodwill of the complainant's mark, or otherwise mislead internet users. The respondent, on the other hand, needs to show credible pre-complaint website content corresponding to a dictionary meaning or geographical name significance of the term comprising the domain name, as opposed to targeting the trademark owner or its competitor. Panels have recognized that using a domain name to host the park page with pay-per-click points, links related to the dictionary meaning or geographical name significance of the words comprising the domain would be permissible and consistent with respondents' rights or legitimate interests under the UDRP. Other relevant considerations may include whether the respondent has registered and legitimately used other domain names containing dictionary words or phrases or geographical names in connection with their respective dictionary or geographical name meaning. To sum up then, while registrants may not have an inherent right to domain names consisting solely of dictionary terms or geographical names, these are very difficult cases. Unless there is clear evidence of targeting, complainants will want to carefully assess whether their case is suitable for the UDRP to ensure that filing of a complaint would not constitute reverse domain name hijacking. Complaints against domains consisting solely of dictionary terms or geographical names, in my opinion, should be brought where there's clear evidence of targeting and abuse and not otherwise. Thank you.
Okay, great. No chime there. Well said. To take a contrary view, Dan, I believe you are up next.
Okay. So I've been given the glorious task of arguing that registrants do have an inherent unfettered right to registering all these dictionary terms and geographic terms as domain names. Now, unfortunately, I've read the UDRP, so I know that there's no unfettered right in that you couldn't register a dictionary word for the express purpose of, running a counterfeit website on a brand. So what I will say this is that, yeah, you have an inherent right, provided you've got some little good faith hook. Okay, so let's start off here. The internet wasn't created for brands. It was created for communication. The UDRP is this little policy applied to domain registration that protects trademark owners from unfair conduct by domain holders. So we got to focus on this unfair conduct. I put it to you that a dictionary term or a geographical term is automatically registrable by all as a theoretical issue. I can open my dictionary, maybe I'm an 8-year-old kid, pick a word and say, that's my domain name. I've never heard of a brand. I live in, I don't know, a faraway country and I don't have a television. So that's no problem. I have that right. And unlike trademark registration, there's no kind of search and check whether there's confusion taking place. I can register it and I'm A-okay. Now, if I choose Nike.ca, let's say it was available, I can't go so far as to then run a clothing and footwear store there because I'll fall squarely within the, intentionally attracted for commercial interest through trademark confusion element in the bad faith of UDRP. So I have some limitations, but I can, as per Doug's orange example, put an informational website about the Greek goddess Nike, or if I'm this 8-year-old boy in this faraway country with no television, I can use it for whatever I was going to use it for, the name of my club. The issue then comes, if I know I can use it in good faith, and I know I can't use it in bad faith, do I have an inherent right to own this domain name if I do nothing with it? Can I just buy and hold a word that happens to be a famous brand? Well, there was a case where someone registered Canadian.ca, which is a famous beer in Canada, Molson Canadian, and that company tried to recover it. And the judge says, there's 1,000 uses for Canadian.ca. I don't see them trying to rip you off. You lose. So I think that a buy and hold strategy would be okay. But then we run into one more problem. There is a factor that says if you have a pattern of registering domain names that match trademarks, that in and of itself, without any offers to sell, without any bad faith purpose, proactively, is bad faith. In addition, the WIPO overview says that there's a highly skeptical view where this dictionary domain is a famous mark. So we have some limitations, but I would put it to you that if you never try to sell and you never try to pay-per-click and you never try to use for counterfeit, I should be able to get a whole bunch of dictionary words for the potential future sale to a good faith third party, a future brand, the Orange Juice Company or otherwise, but I won't target my Orange Telecom company. And because dictionary words are common and the internet is for everyone, until I actually take a step in bad faith, You shouldn't just be able to point to my dictionary buy and hold as bad faith, because I have an inherent right up until I commit that act.
Great, thanks. So we did get some interesting questions coming in as we go. One of them not related to the topic, but somebody's curious to know if the telephone and typewriter behind me actually work. The answer is if you have strong fingers, you can use the typewriter. The telephone doesn't, but they're actually family relics from my grandfather and great-grandfather's wholesale grocery store. On topics related to the discussion today, somebody says, and we'll throw this out there just for your general comment. Somebody says, for dictionary and geographic terms, is it possible that the remedy under the UDRP and the CDRP is excessive transfer of the asset when that domain name has many non-infringing uses, as opposed to possible remedies for regular trademark infringement, such as a sign on a physical store, where a court would never actually transfer the store. They would simply say to take down that sign. Any thoughts in response to that comment?
Okay, Michelle's not answering. It's an interesting question. I've never considered that. So we all know that it's a win or lose in the UDRP and in the CDRP. If you can show bad faith, you get to take the domain. In a situation where someone has a domain which could have been used for proper purposes, but the complainant proves that they were actually trying to, sell it back to a brand owner, like this Nike.ca example, then I guess someone up high could say, well, in that case, we should just do some other remedy. But the way it's set up is if you step over the line, you lose the domain. You could have used it in good faith, but you didn't. I'm comfortable with that, but it's an interesting question.
Yeah, and of course, the policies only provide for, I believe, 3 potential outcomes. That's transfer of the domain name, allowing the current registrant to keep the domain name, or cancellation of the domain name. So, sometimes drawing analogies works with the physical world, and sometimes it doesn't. There are also some comments in the Q&A. Somebody's actually referring to Canadian.biz, not Canadian.ca, apparently seems to be the reference. And Zach, there's a reference to you as having participated in that case. So I know you're not arguing here, but I'll take the moderator's liberty. And if you want to participate, that's fine. And somebody else was asking about France.com. The question simply says, how about France.com? So any thoughts from any of the 3 of you? Otherwise, we can move on.
Zach, I'm happy for you to comment on France.com because it's the same as your Canadian case.
That France.com case, if anybody's interested in reading about it, and I hope to get to it one day because it's voluminous. It's a very complicated situation that started off in France and ended up in U.S. courts. So it's kind of like a strange situation, but it's very interesting. I encourage everyone to read about it.
Doug, you're on mute.
Thank you. There's also a comment that just came in response to the comment that I just made about potential outcomes. It says RDNH, which is reverse domain name hijacking, is a 4th outcome. RDNH is a potential finding that a panel can make in a UDRP proceeding. I'm not necessarily sure that it is a different outcome, but it is an additional finding that a panel can make, of course, when there's been an abuse by the complainant or an attempt to abuse the domain name dispute policy.
Yeah, I agree. I would say it's just a subset of the 3rd outcome. And personally, I've never used the cancellation. So I really see it as 2 main outcomes, though cancellation sometimes is important in .ca. I'll just make this a little plug. If you as the complainant don't have the right to own the domain name because you don't meet certain presence requirements, you may have to go for cancellation instead of a recovery.
And I think that's an excellent point. Under the UDRP, I think the analogy might be if the disputed domain name contains trademarks that are owned by more than just one entity. So typically my practice is when I identify a disputed domain name that contains my client's trademark plus a third party's trademark is to get the consent of that third party and include that consent with the complaint itself. But there are some panelists, I believe, who've taken the position that where that consent is not included with the complaint, that the proper outcome would be cancellation rather than transfer of the domain name, simply because it's unclear that the complainant, the trademark owner who filed the complaint, has the right to register a domain name that contains a third party's trademark. We've gotten a bit afield there. So, and somebody else just posted a question on a comment on cancellation. They says that it's great if it's a bulk filing for 10,000 worthless domains because nobody wants to renew those. That is an interesting point, particularly as trademark owners acquire larger and larger portfolios of domain names. If there are other comments, let me know. Otherwise, we will move on to our next topic of debate. Okay. Hearing none, and bear with me for a moment. All right, so the third, and as I said, final topic today relates to the situation that sometimes arises when a domain name registrant asks a trademark owner for compensation to transfer a disputed domain name. And both the UDRP and the CDRP specifically address this issue. So the UDRP says that bad faith can be defined by someone who registers a domain name primarily for the purpose of selling, renting, or otherwise transferring it to a trademark owner for what is called valuable consideration in excess of your documented out-of-pocket costs directly related to the domain name. That's under the UDRP. And the CDRP contains similar language, but refers slightly differently to what it says is the valuable consideration in excess of the registrant's actual costs in registering the domain name or acquiring the registration. But as we talked about before, buying and selling domain names can be a perfectly appropriate activity. I suspect many of us on this call have helped clients buy and sell domain names, sometimes for high prices, even into the 7 figures. So that leads us to our last poll question of the day. Let me see if I can launch this. So take a moment now to look at the poll question and answer yes or no whether you think a demand for money is evidence of bad faith. About 10 more seconds. All right, we will close the poll and share the results, which are interesting. So about 2/3 say the answer is no, that the demand for money is not evidence of bad faith, while about 1/3 said that it is. So to address this topic first, apologies for getting the positions wrong and introducing the last topic. You can correct me if I've got them reversed again. But I believe that Zach, you are going to speak first and argue for the position, again, which may or may not be yours, may or may not be your clients, but for this exercise today, you'll argue for the position that a demand for money is evidence of bad faith.
Thank you, Doug. So if you get a demand for money and you're a brand owner, you're probably a cyber squatter. I think there's a similar joke, something along those lines. The extortion and hostage taking domain names is something that the UDRP and CDRP were created to specifically address. That kind of extortion and hostage taking is one of the primary purposes of these procedures. The difficulty is, though, that the cyber squatters have become quite adept at obfuscating their extortion and hostage taking attempts through a whole bunch of methods. I'm going to go through as many as I can in my remaining 3 minutes. But the first kind is the helpful guy. You send a demand letter to them and they say, you know what, I was just registering this domain name to help you, the brand owner, out. I'm saving it for you. And I'm willing to turn it over for $20,000. Then there's the Warren Buffett wannabe. He or she registers the domain name and demands a percentage of the brand owner's revenue. 2% sounds reasonable in the circumstances. That's another kind of demand for money that amounts to extortion. Then there's the sneaky settler. This is someone who waits for your demand letter as the brand owner to come. And then they say, well, got your complaint or got your demand letter, and we'll settle the case with you for $25,000. Another kind of extortionist. Then there's the innocent rube, who you write the demand letter to, and they say, you know, I bought it from the registrar, it was available, it's my property, so I can sell it to you for any price I want. Then there's the international cat burglar. This is someone who registers domain names that correspond to the brand in a whole bunch of CCTLDs that you haven't yet gotten a chance to register. Then there's the joint venture. I love this one. This is the person that registers the domain name, and once they get the demand letter from you, says, you know, let's go into business together. I'll put up the website and then I'll share revenues with you. Doesn't matter that the complainant's Coca-Cola and they don't give one damn about this cyber squad as a joint venture. Then there's the UDRP cost expert, very insidious. This is a sophisticated cyber squatter that is very familiar with the cost of a CDRP or a UDRP and will then demand as an extortion attempt a price either matching or slightly lower than the cost of a UDRP or CDRP. Then there's the developer. This is the guy who registers a domain name that corresponds to the complainant's trademark and says, but I meant to build a site on it. In fact, it's ready to go any moment now. It's only been 10 years. Then there's the fantasist who, you know, gets a demand letter from Louis Vuitton over a corresponding domain name and says, but my dog is named Louis Vuitton. In fact, many of my friends call me Louis Vuitton. That's why I registered. I had no bad faith intent. But if you really want it, I'll sell it to you for $3,000. Then there's a similar kind of person, the do-gooder. The do-gooder, this person registers, you know, mycitibanklogin.ca in order to one day create a forum for people to make complaints about Citibank. That was his explanation. And then there's a couple more rare cases, like there's the sphere. This is a person that registers a domain name years in advance before a complainant even adopts it as a trademark, but somehow knows that one day someone's going to want this domain name and then extorts them by making a huge demand for money. Those are 12 kinds of extortion attempts. So you've got to keep an eye out for all these demands for money. Thank you.
Wow, that's a great list, Zach. I was trying to think of other possible examples to add to the list as you went, but I think you were pretty extensive there. Okay, so Michelle, I think you are up next, and you can add your arguments to this debate. Go right ahead.
Thank you. So generally speaking, panels have found that the practice of registering a domain name for subsequent resale, including for profit, would not by itself support a claim that the respondent registered the domain name in bad faith with the primary purpose of selling it to the trademark owner or its competitor. Circumstances indicating whether or not a domain name was registered for the bad faith purpose of selling it to a trademark owner are highly fact specific, as pointed out by Zach, but also important are the exemptions. When looking at that, the nature of the domain and the use to which the domain is put, particularly the absence of circumstances indicating that the respondent's aim in registering the disputed domain name was to profit from or exploit the complainant's trademark, can inform a panel's assessment of the respondent's intent. And such circumstances were discussed in our last question that would include, for example, credible pre-complainant website content that corresponded to a dictionary meaning of the term comprising the domain name as opposed to targeting the trademark owner or a competitor. Panels have also viewed a respondent's use of negative keywords or similar means to avoid links or content that capitalize on a trademark as relevant in assessing a respondent's overall intent. And panels have generally found that where a registrant has an independent right to or legitimate interest in a domain name, an offer to sell that domain name would not be evidence of bad faith for the purposes of the UDRP, irrespective of which party solicits the prospective sale. And importantly, this also includes generalized offers to sell, including those on a third-party platform or auction site. In other words, domain speculation and selling of domain names at a profit is not bad faith in and of itself. It's the targeting of trademarks that is. A respondent is perfectly within its right to register a generic or commonly descriptive term in expectation or hope that it will prove to have a value to a third party and may eventually be sold at a profit. Panels have also found in such cases, again, where there's no targeting, that responding to an offer to sell is not bad faith, and that price, importantly, is not determinative. In a 2017 case involving the domain pinksheet.com, the panel was not offended by the fact that the respondent requested a purchase price of US $100,000 following the complainant's unsolicited inquiry. In finding that the complainant had not been targeted, the panelist explained, quote, "In any market for commodities, domain name brokering is about matching supply with demand. And in the absence of any indicia of bad faith, there's nothing wrong per se with what the complainant characterized as an excessive offer." And similarly, in another 2013 case involving the domain coldfront.com, the panel found that where the respondent has legitimate interest in the domain name, it has the right to sell that domain name for whatever price it deems appropriate, regardless of the value that appraisers may ascribe to that domain name. Accordingly, these exemptions are also important, and it cannot be said that a demand for money necessarily is always bad faith.
Well, perfect timing. Okay, the only comment that has come in while the two of you were speaking, and I apologize that I did not see when it arrived, so I think Michelle and Zach, you can both take credit for this. The comment simply was a one word from a attendee who says impressive. So I think that's true of what you both said, and Dan, of course, from your comments as well. But Zach, you want to take a moment? Is there anything that Michelle said that you would like to respond to?
Well, I thought Michelle explained it very well. In fact, I believe what she said, so I'm going to have to step out of character a little bit. But you know, the fundamental issue with selling domain names is that, yes, if you're registering a clearly infringing trademark that has no conceivable use other than for the brand owner, and like, you know, I love it. I always go back to my Citibank log, and like, that's just like right for fishing. What else are you going to do with it? If that person makes a demand for money, it's obviously extortion. But if somebody registers a very common word, you know, as Michelle pointed out, let's say, wallpaper. Well, you know, the magazine might have may covet that domain name and may want it, and there may be other brand owners that have registered trademarks for wallpaper. But in that case, the complaint's going to have a real uphill battle demonstrating that the respondent targeted that particular complaint, and that was the reason for the registration, because the respondent's going to be able to say, well, listen, you know, the value in the domain name is wholly independent of the complaint's trademark. Wallpaper is much more common than the magazine. That's the reason why I registered it. And so if you have a legitimate interest in the domain name for that reason, because of its inherent value, so wholly apart from the trademark value of it, then as Michelle pointed out, you're perfectly able and you have the right to demand whatever price you want. And you know, that also goes for the situation where if you buy some land along the waterfront and there's nobody around there, and then a brand comes along and builds a beautiful hotel condo complex next to you, the price of your land goes up. And that's just, you know, the good fortune of having purchased that land there. And so that works with brands as well. A brand that gets adopted after the domain name registration is going to have to pay a lot more to get that domain name registration.
No, I'll add one point on that. You know, the UDRP is not the be all and end all. It's like a quick rapid solution to go after bad faith. In a situation like Zach just said, where a clever speculator picks a domain name that becomes a famous brand, you might not be able to win a UDRP, and it might not be bad faith to ask for money. But as the brand owner, you do have remedies, because if ever that domain name is used for a hint of bad faith, you can just go into court and, you know, get injunctions, get recovery, get damages. So the thing to keep in mind is that we always have our trademark rights at court on top of this domain system.
Excellent point. Any other comments? Okay, hearing none, I'll read another comment from the Q&A, which says excellent presentation. So thank you. Oh, and I'm sorry, there were a couple other questions that came in. Let me just take a quick look. Oh, so this is a great question. In your view, does it make a difference which party solicits the sale of a domain name, the respondent versus the complainant?
I'll take a quick stab at that one. I think it does in many cases. The issue comes up in a situation like this. A complainant has a registered trademark, is contemplating bringing a CDRP or UDRP, and the complainant then makes an offer, either informally or through a proxy or directly through its attorney or solicitor, to the registrant and says, I'm interested in buying this domain name from you. Would you accept $5,000 from it? And then the respondent replies, well, I'm not crazy about 5,000, but 15,000, that I would be interested in. In that kind of a situation, you know, a counter offer to a complainant's, solicitation isn't necessarily indicative of cyber squatting. But then again, it goes back to the context of what's the nature of the domain name. If a complainant made that kind of an offer to purchase it for 5,000 when it's a clear trademark infringement, like mycoca-cola.com, then perhaps the panel would even forgive the subterfuge that the complainant did in soliciting this evidence of bad faith. But if the complainant did that, and then to try to see if it could genuinely buy the domain name because it believed it had to buy the domain name because it had no colorable rights to it to get it through UDRP, and then brings the UDRP on top of it as its plan B when its commercial efforts to purchase it failed, a panel may look at that very skeptically and say, the complainant in that situation almost indicated that, kind of expressed that they have no rights to it. They tried to buy it, and then then their whole complaint is taken far less seriously, and it might even be reverse domain name hijacking.
One last question, because we only have a few minutes left, but somebody asks in the Q&A, is it safe to reach out to a mark holder with an identical domain name that your original registration predates their mark, and only offer them the option to lease the domain name in perpetuity with no road to ownership?
I'd say that the leasing is red herring, whether you're leasing or selling. If you had earlier rights and you were a speculator and there's no bad faith to be found under any rock or tree, then you could, when you see a potential purchaser being let's say a new brand owner, try to negotiate a deal. I think that would be okay. And I think the leasing versus the selling doesn't matter.
Yeah, I agree. I would agree with Daniel. I would point out one additional consideration. That's that when a complainant brand owner gets a solicitation from a domain name registrant, and the domain name registrant says, how would you like to buy my name, bricklayer.com, something that the registrant has every right to, like the student. But the complainant still has a trademark for bricklayer. The first inclination of the brand owner generally, and maybe Daniel and Michelle will agree with you from their own experience, isn't to say, thank God I've been waiting here for someone to come like you to come and offer me that domain name. Their first call is to someone like Daniel, Michelle, or me and say, illegal on the phone. There's someone trying to extort me. And so it's often asking for trouble to make that solicitation, even if the respondent is well within their rights.
Great, thanks. Well, unfortunately, we're just about out of time. So I want to thank Michelle and Zach and Daniel for your time today. I'll go out on a limb and say that if there are questions that the attendees have that did not get answered, perhaps some or all of the participants would be happy to entertain hearing from you by email. I know I would be happy to do so. I'm going to hand it back over to Barry, and I'll just go ahead and give a plug for the CII DRC website itself. Barry, in case you're hesitant to do that, there's some great resources on that website about both the UDRP and, of course, the CDRP, including the policies and the rules that we've been talking about today, links to decisions, document creation forms, and an extensive FAQ of frequently asked questions. So with that, Barry, I will turn the program over to you.
Thanks, Doug, and thanks to all of our presenters. For those of you who have been watching, like me, I hope you found it as interesting and stimulating as I did. I really think this was a meaningful opportunity to learn more about the whole jurisdiction, everything to do with internet domain name disputes. And I've seen some of the comments from people saying, can we do this on a regular basis? It does take a lot of work. So again, I want to thank our participants, our panelists, because we did work on this over the last month or so extensively. So thanks to everybody for their contributions. And Doug, thank you also for, yes, mentioning our website. Please check that out. And again, you can initiate complaints right through the website. We've tried to make it as easy to use as possible, as interactive as possible, and try to reduce the consumption of paper as our contribution to environmental stewardship. With that, again, I want to thank everybody for tuning in. We have applied for CPD, Continuing Professional Development Credit, in a number of jurisdictions. We've been approved in British Columbia, unfortunately not successful in Ontario. You might want to talk to your regulators there about why, but stay tuned. We're waiting to hear back from a few other jurisdictions. For those of you who have registered to watch and attend this event today, we will get back to you with an update on where CPD credit has been approved. So watch your inbox for updates, and hopefully you'll be able to claim some CPD credit to start the year off right. And with that, I want to wish you all a very successful day and the rest of your week. I hope it goes well. Thank you very much for joining us.